going to do.
That's fine.
I'm just going to, no, do not talk. Stop.
I said I won't say anything else.
Stop. You can kick her out.
Before we even begin, buckle up, because this is one of those hearings where things go from procedural to personal in seconds. What starts as a simple issue about whether both parties receive the same documents quickly spirals into accusations of unfair treatment, frustration boiling over, and a judge who's clearly had enough. Know here's the key. This isn't about who's right or wrong in the underlying dispute. This is about courtroom procedure, and that matters. In court, both sides must receive every document submitted. If one side doesn't have it, the judge legally cannot move forward. It doesn't matter how frustrated anyone feels. Due process isn't optional, but when one party believes the court is dragging things out, and the judge believes he's simply following the law, sparks fly, and once tone enters the equation, that's when authority gets tested. Watch closely, because this moment becomes less about paperwork and more about respect. Who do you think crosses the line first?
Good morning.
Gil Stanford. All right. Ms. Norman, can you state your name?
Susie Norman.
Okay. And that's a wrong screen. No, it's okay. I'm good. All right. Where are we on this case, folks?
At the last hearing, we were reading on the evidences I sent. One was a flash drive.
Yes.
Due to the weather and the courts being closed, it hadn't been logged yet.
Correct. I think also, we have it now.
Yes. And I believe that your coordinator helped Mr. Stanford to play his flash drive.
Right. Did you get all the stuff off of the flash drive?
I did see the video of the previous hearing on that, yes.
Okay. And so, with reference to that previous hearing, you have something you're holding up. What are you trying to do?
I submitted to the court an answer to that, and I sent a copy to her. I don't know if she's received it or not yet.
Is that the response to defendant's objections and evidence submitted about January 15, 2024 hearing? That's what you, okay.
That's correct.
All right. Have you received that?
I have not.
Okay, folks. All right. All right. Somewhere along the line, we've got to make sure, because it becomes impossible for me to conduct a hearing where one party has submitted something and the other party doesn't have it. And I'm not saying, I'm not blaming either party. I'm just saying that's the cold-hearted reality of where I end up.
Your Honor, may I say something?
How did you say?
Let's pause right here, because this is important. The judge is explaining something fundamental. He cannot conduct a hearing if one side hasn't received the other side's filing. That's not favoritism. That's constitutional due process. If he ignored that and ruled anyway, the case could be appealed and potentially overturned. Notice he even says he's not blaming either party. He's simply stuck in the middle. This is one of those moments where frustration meets legal reality. Miss Norman clearly wants this over. She feels it's dragging on. But the judge is operating within strict procedural boundaries. And here's the question for you. If you were in her position and believe the other side waived claims previously, would you be patient, or would you feel like the system was stalling? Because right now, tension is building, and tone is about to change everything.
Send this to Ms. Norman.
U.S. mail.
Okay, well,
yeah,
that's going to be.
I thought our hearing was later in the month. I thought she was going to get it, and I just got the notice about our hearing date yesterday. So I was thinking maybe.
Well, that maybe should tell you something about the mail. All right. Here's what I'm going to do. I think we have Ms. Norman's email, right?
Yes, sir.
Okay. So,
Judge
folks, I'm
Simpson,
not sure that, yes,
can I
ma'am.
say something, please?
Yes, go ahead.
That video from the hearing from 10/22 of 2024 has on there where Mr. Stanford waived his right to monetary damage and rent because of the case, and my case being I dismissed my case in order to come to that end. So I don't know. I just feel like at this point, it's, we're just on the court's time and we're wasting it with,
Well,
all of these things.
Ms.
It's just-
Norman, I understand what your position may be. My position is that if somebody submits something to the court, I have to at least look at it and consider it. The very fact, I don't think, if you think about the last hearing, you submitted something and I didn't get it because of whatever the circumstances were. I didn't have it. I don't think you would want me to proceed without having that. Mr. Stanford has submitted something. I'm not going to have a problem going through it. You just have to have it so that you can respond to it if necessary, because you're entitled to have it. Here's what I'm going to do. At this point, there'll be no additional filings. All right, because I don't want to end up in this circumstance. We have Ms. Norman's email?
Yes, sir.
All right. So what I'm going to do to expedite the process, Ms. Norman, because normally I'd put it out however long it may take the mail to get there. I'm going to have my staff copy what Mr. Stanford has submitted, email it to you so that you have it. Okay? And then...
So what
My
happens
next-
then? He's got an answer to the video, and then I see something on his answer, but yet I can't answer.
Then you guys can argue that before me. Ms. Norman, I can't force this to go any different.
I don't
If
want to
I could-
argue. I want it to end. I want it to end. And this is just how we were in October of 2024. Frustrating you.
So I am not frustrated. I'm frustrated by your failure to
I'm not a failure.
permit the court to
I'm not a
proceed
failure.
with how it has to proceed. I just explained to you why I can't do it the way you want me to do it.
Because he submitted an answer. Is that correct?
What did I just tell you, Ms. Norman? What did I just tell you?
This is the turning point. Up until now, the judge has been measured, calm, procedural, almost accommodating. He even offered to expedite things by emailing the document instead of waiting for mail. That's actually him trying to help move it along faster, but when Miss Norman continues pressing after he's already explained the reasoning, the judge perceives it as interruption and possibly disrespect. Courtrooms operate on order. Judges control the flow. Once a judge feels that authority is being challenged repeatedly, patience can disappear quickly. Notice the shift in tone. What did I just tell you? That's no longer procedural. That's frustration surfacing. And when frustration meets perceived rudeness, consequences follow. Do you think she crossed a line here? Or do you think she was simply advocating for herself? Because the judge's reaction next is swift and final.
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case. He is.
Norman, I'm
I'm
going to
just-
tell you this, and then I'm not hearing anything else from you. I'm going to do what I got to do.
That's fine.
I'm just
That's
going to,
fine.
no, do not talk. Stop.
I said I won't say
Just
anything else.
stop. Just stop.
That's how you treated me in October of 2024 as well.
I'm done. Then here's what we're going to do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yeah, Yep, we'll just put it out so she can get the mail. I'm gonna do it that way. I was trying to expedite it for her, but she's gonna treat me rudely. It's not gonna
Don't
happen that
treat you
way.
rudely.
Give
I'm
me a
very
date. I'm
respectful.
done. Mute her, because I'm done with you.
March 10th.
March 10th. I'm adjourning this to March 10th, 2026, 9 a.m. Thank you. You can kick her out.
Thank you, see you then.
Yep.
And just like that, the hearing is adjourned, pushed out even further. What was meant to be expedited ends up delayed because courtroom decorum broke down. Let's break it down clearly. The judge was obligated to ensure both parties had the same filings. He offered a faster solution, but once he felt he was being treated rudely, he reverted to standard procedure, which meant waiting for mail and setting a later date. That's a powerful reminder in court. How you communicate can directly affect how smoothly things move. This wasn't about monetary damages anymore. It became about control of the courtroom. Judges maintain authority not just through rulings, but through tone and boundary. So what do you think? Did the judge overreact, or did Miss Norman push too far? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe this channel for more jaw-dropping courtroom breakdowns.